Hi everyone, here's video 2 for week 6. I thought I better do I haven't done a YouTube video for a while on Common Law 1. I thought I better, so you can see Lainey. Don't want you to miss your mascot too much. And there she goes. Alright, so in this video we're going to talk about McCulloch versus Maryland and the necessary and proper clause. In the last video, I think we got a good, hopefully you took a little tour through Section 8 of Article 1. You'll notice that after 17 different enumerated paragraphs that there is an 18th paragraph. That is kind of curious because the first 17 are, they're fairly specific, they're varying degrees of generality. But things like coining money, raising armies and navies, declaring war, regulating naturalization, building post roads, these are not hard to understand, and they're quite specific. Then you have this 18th paragraph, and this is called the necessary and proper clause. I think it's safe to say that any time you have an essay on legislative power, whether it be on a common law exam at Cooley, or whether it be the bar exam, it would be worthwhile, first of all, of course, to cite your text, Article 1, Section 8. But in almost any case, you could cite the necessary and proper clause. Here, I'm going to make two key points about the necessary and proper clause. So I mentioned McCulloch versus Maryland. This is the case where the court definitively defined or explained how the necessary and proper clause works, to the extent that it doesn't explain itself. What had happened here, Maryland wanted to tax a federal bank. Of course, the federal government objected to that. You can't tax a federal bank. The federal bank is immune from state interference. And Maryland is arguing, sure, we can tax the bank, because the bank is not even constitutional. You're not even entitled to have a bank, so we can tax it all we want. So that has to sink in. Right? The argument here, the argument that the court is really taking up is the argument whether the federal bank, a bank created by Congress, is legitimate. And that's a critical point. This is a bank created by Congress, and Maryland is saying Congress didn't have the authority to create a bank. It's again, a federal bank, Bank of the United States. So we're back to our very simple, almost elegant in its simplicity, argument. Okay, constitutional law is the body of law that answers the question, can the government do that? And as I've said now umpteen times, the answer to that question depends which government you're talking about. Are you talking about a federal court? Are you talking about the federal Congress? Are you talking about the president? Or are you talking about a state? That's critical to know before you can even try to answer the question whether the government can do that. Now, if Maryland is saying, and it is a federal court saying Congress exceeded its authority by creating a bank, remember what I said in the last video, then the judge is going to say, well, what do you mean? And you're going to have to explain, if you're Maryland, well, there's a list of things in the Constitution that Congress is allowed to do. Why, where, the judge says. You know the answer to this, right? Why, where? Why, Article 1, Section 8, that's a list of things. Oh, well, it's just a list of suggestions, right? It's just kind of a guidepost. No. Expressio unius est exclusio alterius, it's the law, and it is a list, and whatever's not on the list is not on the list. So you always build up right from your general propositions. Article 1 governs, Section 8 has a list in it, that's an exclusive list, right? These are general propositions to get more specific. Okay, so I'm the judge, I say, all right, Maryland, I see your point, so there's a list here. Okay, so what's your problem with the bank? Here's your problem with the bank. The problem with the bank is it ain't on the list, right? There's nothing in Article 1, Section 8 that says bank. Now you have to concede what you have to concede. It doesn't say bank anywhere in Article 1, Section 8. It doesn't say Congress may create a bank. So, Congress says, we understand that it doesn't explicitly, expressly, right, the lawyers for Congress say, we understand it doesn't expressly say bank. But it does say, look at that 18th paragraph. So this is so crucial, the text of the Constitution, to look at it, to not just treat it as syllables, but to think about what it means. The lawyers for the United States say, the 18th paragraph of Article 1, Section 8 says that Congress has the authority to do whatever is necessary and proper for carrying into execution the foregoing powers. And so its argument is that a bank is a necessary and proper means. This is so important, this whole idea of means ends. We've talked about it before. Courts often look at that, the means, okay? The necessary and proper clause gives Congress the means by which, or authorizes Congress, right, to develop means by which it would accomplish the ends. What ends? Well, the ends that are spelled out in the preceding 17 paragraphs. Those are the things Congress is allowed to regulate, things that Congress is allowed to do, and the question is how is Congress going to do it? There's quite a bit to do there, and how is Congress going to do it? How much leeway do they have? So Congress says this is an appropriate way to carry out our enumerated powers. So here comes the first of my two big points about McCulloch versus Maryland. And let me repeat, there are two big points. One, is the necessary and proper clause some kind of freewheeling, independent grant of authority to Congress, independent of the other 17? In other words, well, Congress would love this, right? If the Constitution said you can do these 17 specific things, and then at the end adds plus whatever you think is necessary and proper. Well, if that's what the necessary and proper clause meant, then there was no use to have a list to begin with, because if Congress can do whatever it thinks is necessary and proper, then there are no limitations, there is no meaningful list. So the court says it can't mean that. Now look carefully at the text of the necessary and proper clause. Okay, and if you're looking in your book, it's page 1805. It says, Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution the what? I want you to stop there. Look at that word. Okay, necessary and proper for carrying into execution the what? Foregoing powers. What does foregoing mean? Foregoing means the ones that were just mentioned. The necessary and proper clause is not a free-floating, independent grant of authority to Congress. The necessary and proper clause, this is point number one, links back to the enumerated powers. In other words, when you're arguing for the government and you're using the necessary and proper clause, the judge will ask you, okay, necessary and proper to do what? Okay, I get you're saying it's necessary and proper. Necessary and proper to do what? And think about this. Your answer to that question had better be something that is on the list. This list in Article 1, Section 8. Okay, you say, Your Honor, it's necessary and proper. It's under the necessary and proper clause. Congress is invoking the necessary and proper clause. Judge, okay, good. Necessary and proper to do what? Your answer has to be something on the list. That's the first big point about the necessary and proper clause. I still remember my con law prof driving this point home. Don't use the necessary and proper clause. Don't regard it, don't characterize it as an independent grant of authority to Congress that's unlinked, untethered from the enumerated powers that come before the necessary and proper clause. You must link it back, always link the necessary and proper clause back to one or more of the enumerated powers. And we'll apply that in a separate video, but that's the rule. The second big point out of McCulloch versus Maryland is the court has to decide what necessary and proper means, and especially the word necessary. Because what Maryland is arguing here is that, well, maybe a bank would be nice for Congress to have, but it's not necessary. It's not, because what does necessary mean? Maryland is arguing that necessary means absolutely required. There'd be no way to carry out the powers that you have in Article 1, Section 8 without a bank. If you don't absolutely need a bank, think about this, then a bank isn't necessary. And it's interesting, here the court gets into an argument about verbiage, about words that we might still have today. It turns out that when you say necessary, that can mean a couple of different things, and the same was true back in the days of McCulloch versus Maryland. What does necessary mean? Now, in one sense, if Maryland is right. So if I were to say to you, to get an A in this course, it's necessary that you score at least 85 points out of 100. If I use necessary in that way, in the context of that sentence, you know that necessary means absolutely required. There's no two ways about it. Can't happen without. Sine qua non, if you want some fancy Latin. So in one sense, necessary means absolutely required. On the other hand, have you ever had this conversation with, I don't know, somebody, usually probably somebody in the family or a friend or most likely a kid, where you say to somebody, you know, was that really necessary? I know I've had that conversation. Was that really necessary? And when I use the word necessary there, I don't mean absolutely required, right, as a means for carrying something into execution. That's not what I mean. And to stop and think about that for a minute. When you say to somebody, was that really necessary, what are you saying? Okay, now having had a chance to think about that, what you probably mean when you use the word that way is appropriate. I'm not asking you whether it was absolutely required. I'm asking you whether it was smart, appropriate. You know, was it wise? We could have done without that. It wasn't appropriate. So this is the question facing the court. Does necessary mean absolutely required, or does necessary mean appropriate? You know from your reading, the court landed on appropriate. We'll talk just for a second about why, and then I'll close out this video. The court did not want to become a supervisor. Can you imagine the litigation if the court would have said necessary and proper means absolutely required? Congress is not allowed to do anything that is not absolutely, in our judgment, absolutely required, absolutely necessary for carrying into execution its foregoing powers. Right? It can't do anything. Coin money, raise armies. Anything that's on this list, we have to decide whether it's absolutely, positively required, that it would be impossible for Congress to do its job without whatever it is that we're looking at under the necessary and proper clause. If the court would have gone down that route, it would become a super legislature, basically. Right? It would be sitting in judgment on every single expenditure, on every single appropriation, on every single thing Congress did. I mean, you'd have the court then deciding how many people should be in the military. There's questions like that. So you can see a little bit of political question doctrine coming in here too, right? We don't want to interfere, the court, we don't want to interfere with another branch's work. And we're concerned about our own docket. We don't want to be supervising every single little thing Congress does. That's probably, in large part, why the court said we interpret the word necessary and the necessary and proper clause to mean appropriate. So this is an introduction to something we'll talk about a lot in Con Law 2, but I want to mention it here so you bookmark it, of something called rational basis review. If there's some legitimate thing that the government is doing, and if it's listed here in Article 1, Section 8, then as to Congress it is legitimate. And if the means are appropriate, look at that language from McCulloch. Let the means be appropriate, let they be within the letter and the spirit of the Constitution, then whatever Congress chooses to do to execute its own powers in Article 1, Section 8 is constitutional. So, that's the necessary and proper clause. Two things to know. Number one, it links back to enumerated powers. You must always link it back to one or more of the enumerated powers, which means that you have to be familiar with the enumerated powers. Again, you don't have to memorize them, but you have to be familiar with them. So link it back to the enumerated powers. And number two, you have to know what necessary means. Necessary means appropriate, so that gives Congress some leeway. Congress can do anything that's appropriate. It doesn't have to be absolutely required, as long as it's appropriate within the letter and spirit of the Constitution. It's good to go under the necessary and proper clause. So we'll go ahead and apply that in the next video, but those are the rules.